Hi, my name is Chris Shoemaker, and this is my presentation for IL 707 on due process and its impact on education. Hope you enjoy. This presentation will focus on two essential questions when it comes to due process and its impact on education. The first question, why is due process important to education? The second question, what legal cases link due process to education? I'll also be providing some additional insight, such as my opinions from my experiences as a teacher and administrator, and specifically as educators, what we need to think about when it comes to due process and its impact. So, why is due process important to education? Well, for starters, due process provides legal fairness under the Fifth and 14th Amendments. Specifically, the Fifth Amendment limits the power of the federal government, while the 14th Amendment, the most popular amendment in terms of court cases involving violation of student legal rights, limits the power of state and local governments. One thing that due process does not do, due process does not guarantee results for one side or the other. However, due process does two very key things. It does prevent arbitrary and unreasonable decisions. It also gives ample notice, opportunities for comments from all parties, and the chance at a hearing to be ruled on in favor of by an impartial hearing officer or judge, that sort of thing. And finally, one very important aspect of due process as it relates to education is it created for and established procedural safeguards. These procedural safeguards were born out of due process. This is most popular, and you'll hear most about this in issues regarding students with disabilities, such as IEP meetings and things such as that, where students are protected under the Individuals with Disabilities Education Act. Procedural safeguards must be followed. Students and parents must be given the opportunity to receive these safeguards, read over them, ask any questions of them. This is a bare basic point when it comes to due process. Those are procedural safeguards, a very important part that has come out of this, and that's why another reason why due process is important and has had a profound impact on education. These next few slides, we'll go over some different legal cases and their impact regarding due process and its link to education. The first of these court cases, Goss et al. Versus Lopez et al., was ruled on by the United States Supreme Court on January 22nd, 1975. This particular court case involves students from Columbus Public School System in Columbus, Ohio. 9 students in total were involved, and they were all suspended for different types of campus disturbances. The students were suspended without hearing, and for what the students said and parents argued was for an unreasonable amount of time. Now, the disturbances occurred on different parts of campus, classrooms, auditoriums, cafeteria, hallways, those different areas of the building, and the school board supported the administration's decision to suspend, citing a disruption in the learning environment. However, these students and parents filed for suit against the school district for what they said was the violation of their students' 14th Amendment rights to due process. The United States Supreme Court ultimately ruled in favor for the students because they were not giving notification, opportunities to respond, no witness statements were taken, and the suspension was held without a hearing. The significance of this case for educators and especially administrators always give due process on situations involving suspensions and expulsions. This is just a good rule of thumb. In my experience, always trying to do what's in the best interest of students and not just hammer out a punishment or a consequence and keep it moving, but rather always work with parents, work with kids, and giving them their due process. Also, in many districts that I've worked for, situations involving expulsions automatically require a hearing at the district level with a independent hearing officer. And so this kind of protects against not giving due process as well when that hearing is automatically required. However, it is up to the principals, the assistant principals, the administrators involved in the district to always remember to give due process on situations involving suspensions and expulsions. The second case, Ingram et al. Versus Wright et al. This court case involves students in the Miami-Dade County, Florida area that were middle school students. These two students, Ingram and Andrews, were the subject of corporal punishment and also the violation of due process. These two students were paddled for violation of school rules. Ingram was paddled for what the school said was slow response to teacher instructions. He received over 20 licks, suffered a hematoma on his buttocks, and required medical attention. Andrews was paddled fewer times, and for minor infractions, he was paddled twice across the arms. He lost the use of his arms for a week and also required medical attention. Now, the students' families in this situation filed suit against the Miami-Dade County Public School System for violation of two amendments. The students' Eighth Amendment right to cruel and unusual punishment, and the students' 14th Amendment right to due process. After much review and discussion and deliberation, the United States Supreme Court ultimately ruled in favor of the school district. This is interesting because corporal punishment being used in schools today does not violate the Eighth Amendment, according to the United States Supreme Court, nor do they have to be given a hearing. So that is significant going forward when you're faced with situations where you may want to use paddling as a form of consequence. Technically, you don't have to give due process in that situation, and technically it does not violate the constitutional amendment against cruel and unusual punishment. The court said that it applies to criminal punishments and does not roll over into the school setting. For me personally, I know the United States Supreme Court ruled in favor of the district in this case. However, I'm against corporal punishment. I feel like it just opens up too many problems for you down the road. I've had parents who have requested corporal punishment instead of in-school suspension or out-of-school suspension. However, I just don't feel comfortable doing that even in front of witnesses. And I know that administrators and districts still use corporal punishment, but I personally don't agree with it and don't use it as a form of consequence for addressing student misbehavior. I do also give due process. I just err on the side of caution when it comes to these sort of things and to not get caught in a situation where I didn't give the student an opportunity to give a statement or involve the parents, take witness statements, that sort of thing. I always give due process, even if it's a situation where corporal punishment may come up and be used or recommended either by parents or principals, that sort of thing. I just don't feel comfortable not giving due process in just about every situation. The third court case I'm going to talk about, and it's linked to due process and education, is the Board of Curators at the University of Missouri et al. Versus Horowitz. The United States Supreme Court ruled on this decision on March 1st, 1978. Now, this case is different as it involves an institution of higher learning, specifically the medical school at the University of Missouri, Kansas City. The institution here dismissed medical student Ms. Horowitz for what they said was her failure to meet academic standards. Documentation shows that during her time as a medical student at the university's medical center or medical school at Kansas City, Ms. Horowitz received repeated reports of faculty dissatisfaction. She was quoted as performing under par, subpar, and less than the performance of her peers. She was recommended to be dropped from the medical school program. Ms. Horowitz appealed this decision to the university's provost. And appeals agreement, the university agreed to give Ms. Horowitz oral and practical exams with seven different physicians that were well respected in the community and across different clinical experiences. Now, as a result of these oral and practical exams, 2 of these 7 physicians still felt that Ms. Horowitz should be dismissed from the program after her performance with them. 2 of the physicians disagreed with that and felt that Ms. Horowitz should be allowed to continue and even graduate from the medical school program at Missouri, Kansas City. While 3 of the physicians remained somewhat neutral, said she should continue in the program, but on a probationary status, and then reviewed again at the end of that year. When it was all said and done, the university upheld its decision, and Ms. Horowitz was again dismissed from the university's medical school. Ms. Horowitz filed suit against the university for a violation of her 14th Amendment right to due process, as she was claiming and arguing that she was not given ample notification, not given a chance to provide her statement, nor was she given a hearing. This case went through several levels of court. The district court upheld the university's decision, saying there was no violation of her 14th Amendment right, while the appeals court reversed this decision, saying that due process was not given nor followed, and was owed to Ms. Horowitz in this situation. But finally, the United States Supreme Court reversed the decision of the appeals court back to the decision of the district court, therefore upholding the university's initial decision to dismiss Ms. Horowitz from the university's medical school. The significance of this case is that due process does not just exist in our pre-K-12 schools. We often assume that due process applies to special education meetings and disciplinary hearings and things like that at the elementary, middle, and high school levels. However, that is not the case. Due process does exist at the higher education level, and in this case, the University of Missouri-Kansas City's medical school program. This is a list of my references that I used throughout the presentation. This first one on right to due process, a very informational link from Lincoln University. It kind of breaks down the specifics that I covered earlier regarding 5th and 14th Amendment protections, that sort of thing when it comes to due process. Also, the next 4 links there go deeper into detail regarding the court cases that I went through. You see the Board of Curators case, the Goss-Lopez case, and the Ingram Wright case. You can click on those and get more specifics as well in terms of the legalese and wording behind those cases as well. Hope you enjoyed my presentation. I felt like I have addressed what needed to be addressed in terms of how and why due process is important to education and to us as educators. I also feel that there's an abundance of court cases out there regarding due process. There is a definite precedent that has been set in most, if not all, situations regarding due process. But overall, I hope you enjoyed my presentation. Hope you can take what has been presented here and enhance your knowledge of due process as well. And as a closing statement or closing remark, I would always just cover yourself and cover your bases and make sure that due process is always given to your students and parents. Always do what's best, what's in the best interest of them. And with that, that concludes my presentation. Hope you enjoyed it. Thank you.